Hello again. This is another one of our online discussions. I'm Matt Puckett. I'm the Executive Director of the Florida Police Benevolent Association. I'm here with Hal Johnson, who is the General Counsel of the Florida PBA, and the President of the Florida PBA, Mr. John Rivera. And we're going to discuss the biggest news of the week, which was the decision by the Florida Supreme Court to reverse the trial court's decision on the FRS case. I'm sure everybody's got questions, and we're going to do questions and answers, and we're going to hear a lot from Hal on the decision and discuss the ramifications in the legislature to this decision. I'll turn it over to the President.
Well, Matt, we're all very disappointed, whether it's down here in Miami or up in Pensacola and Tallahassee. We certainly thought that the lower court was spot on. Her decision, Judge Fulford's decision, was awesome. And she gave it a lot of thought. It wasn't like something that just passed over on her desk. We live under the rule of law. This is America. We don't like some laws, and we love others. We like some decisions, and we don't others. So we have to live with it and move forward. We can't let these types of things hold us back because, one, that's not who we are as a PBA organization. And two, our members deserve so much more. We just got to keep fighting. I think that this is a textbook example, again, of why it's so important for us to elect the right elected officials. And it doesn't get more glaring or more clear for our members and the employees across the state of Florida how important it is that we put the right people into office.
I agree with you 100%. Hey, Hal, could you maybe kind of give us a rundown on the decision, what it means, and where do we go from here legally? Is there anything else we can do?
As far as the legal aspects, there's nothing more to be done. I mean, we put all our eggs in the basket. We went to the circuit court and won on all three counts that we had raised. We had raised a count about a breach of contract. We raised a count about a taking, and they were tied together, and we had a separate count on collective bargaining. All those provisions were under Florida law. The Florida Supreme Court gets to rule on Florida law, and unfortunately, we came up a vote short as far as affirming what Judge Fulford did in her decision. But we've been asked whether we can go to the United States Supreme Court, and the answer is no. We've been asked whether we can file a motion for rehearing, and having studied the decision, it's quite clear that all those judges identified all the issues. While we don't agree with the way they may have ruled on those issues, there's really no basis to go back before them and ask them to rehear any issues, because obviously they heard them loud and clear. 4 voted against us, 3 voted for us.
Explain the hurdle that we had with the Florida Sheriff's decision from 1981, if you could, for everyone, because that's really kind of the linchpin of what the 4 that reversed the decision kind of hung their hat on. Am I right?
You're absolutely correct. And from the very beginning, at least all the attorneys on our side recognized that that was the linchpin. We did convince Judge Fulford to carve out the decision and to distinguish it on the basis that they were not talking about the fundamental tenets of the plan changing. Unfortunately, the Florida Supreme Court rejected that. Now, let me just sort of give you a little bit of background. The lawsuit that was filed involving the sheriff's case occurred when the legislature reduced the accrual rate that law enforcement officers were earning from 3% to 2%. The sheriffs, who were the lead plaintiffs in the case, filed a lawsuit in which we joined and argued that under the contract provision contained in the FRS plan, that those benefits could not be changed. unfortunately, 20 years ago or 25 years ago, the Florida Supreme Court ruled the exact same way, saying that the legislature could change the benefits in various terms of the retirement system prospectively, but could not do it retroactively. So we were trying to get basically the court to change its mind. And the court, obviously, 4-3, found that the sheriff's case was controlling and that they did not see any grounds for receding from that decision, or in other words, reversing that decision, and thus that sort of eliminated the first two arguments we had about violation of the contract clause and about a taking under the law. Then the collective bargaining issue, they merely sort of sloughed that off, saying that there was nothing facially in the law that was unconstitutional because it did not prohibit collective bargaining over retirements. It just changed the collective bargaining, it just changed the retirement law in this case. So that's where we're at, and there doesn't appear to be anywhere to go.
Okay. Well, John and Hal, both of you guys, we've been through this before, how you referenced it with the sheriff's case when they reduced special risk from 3% down to 2%. And as you were saying, John, it took getting our politics right in order to reverse that. That's our way out. This is a legislative decision now. We have the legislature that meets every year. They set a budget every year. We can lobby to try to get the contribution for employees lower or reverse to where it goes back to non-contributory at some point in the future. And the COLA suspension, that there was a sunset provision that was in the law originally in the 2011 reform, and in 2016 they're going to review that suspension. And I know the PBA plans to be there to say they should not only lift and reinstate the COLA, but they should probably pay back the time that was suspended. So we're not out of the woods, but it's going to require us to do what we do best, and that's get our politics right and work the legislative process.
Yeah, Matt and Al, I mean, absolutely, you both are right. And we down here, and maybe it's a good time to also just to simplify it for our members, because we have some members that believe that they're losing yet another 3%. That this decision made yesterday was going to create further cuts, and that's not the fact. The fact is you've already lost it. Rick Scott's already taken it away from you, and we were trying to get it back. Would that be an easy way to say it?
That would be yes, that's the same way to say it. And I haven't heard any talk about them trying to increase the contribution, at least this year.
Right.
Well, and again, that goes right back to, if we have the wrong politic against us or the wrong political winds against us, it could happen. If we have the right political winds against us, not only could we prevent that, but maybe we can lower it back down and go back and reverse this whole thing.
Right.
It's a very hard lesson for all of us to have learned, but this is where the members can help. You got to stay with us. You got to follow our lead. We study the politics. We study the politicians. We do our homework well, and sometimes we're wrong, but I will tell you that overwhelmingly we're spot on, and we pick the right people, and so the percentages are in our favor. Just work with us. If we ask you to vote a certain way, by God, do it that way.
Yep. Well, I can tell you we're in pretty good shape in this upcoming legislative session. We have some very good friends that are in some very powerful positions, and I think they've heard our message loud and clear that enough is enough. That going forward, if we make changes, it does not affect the actives or the retires at all. If changes are made in the future, it should be to folks that have not yet been hired, and even in that regard, we should not basically sell the unborn just to save our own hides. And I think that message has been heard loud and clear.
And we need to continue that message to be loud and clear. And again, that's where our members can rally around us and help us. Help them.
Right, right. All right, guys. Well, I appreciate it. I think, as you said, John, it's been disappointing, but we're going to live to fight another day, and we're not going to give up. And, I don't know how many years it took when we started the fight to get the 2% back up to 3% for special risk, but we prevailed, so it can be done, and that's now our charge to do it.
Yeah. And I want to take this moment on behalf of all the law enforcement officers in the state of Florida, even the ones that are not with PBA, to thank Ron Myers and Hal Johnson. You guys were brilliant lawyers in this thing. We won it through the legal aspect, in other words, the lawyering, but at the end of the day, we lost it politically. It is what it is, and we've got to look to the future. We can't, this is a very long struggle. It's, the whole career. So we got knocked down once, but, we'll knock them down a couple times, and that's the way it goes. And we just got to look positive, stay positive, make sure we take care of our own families, and please, stay safe out there. The streets are getting meaner and tougher each and every day.
Thank you, John, and I agree. Stay safe out there, fellas and officers.
That's right. Stay safe. We love you guys, and God bless you. Take care.
Bye.